Hey, Lauren. All right. Can you see my screen? I just show you slides. Can you see that? Can you see my screen? I think I shared my screen.
Yeah, I can see it. I can see it. Yes,
Okay,
Yeah.
perfect.
I can see it. Okay. Okay.
Yeah, I think we probably need to wait longer because I saw we only have a few attendants, so maybe give them more couple minutes to join.
Oh, yeah. I'm free for the afternoon. Don't worry.
Okay. Thank you.
Okay. No worries. Okay. Got my notes. Okay. I'm ready whenever we're ready to get started then. Are we going to wait
Yeah, I think
much longer?
yeah, I think we can start right now. Maybe they will join later, so we
Okay.
can start right now. Okay. Hello everyone.
Okay.
Yeah, just okay. Welcome to today's IAACE webinar. My name is Molly Ma, and I'm a transportation engineer and work for STV. So I'm gonna be today's moderator for this session. Thank you all for joining us today. And today's topic is understanding the 2025 H1B visa change. So we'll be going over the major updates to H1B program. I know this is a very important and serious thing for all of you, and hope you can figure out your questions and get some helpful information from today's webinar. And now it's my pleasure to introduce our speaker, Lauren understands the panic, an immigration lawyer from Caswellis and Anderson Law. So Laurie has extensive
Hello,
experience in
everyone.
employee-based. Yeah, hi, Lauren. Yeah. So we're excited to
Hello.
have her insights with us. All right, welcome, Lauren.
Thank you. Thank you very much. As Molly said, I am an immigration attorney here in Chicago. I practice all facets of immigration law, from employment-based matters such as EB-1A, NIW, H-1B, as well as asylum, removal defense, family. We're a full-service immigration law firm.
All right, okay. Thank you, Lauren. So before start, just want to let everyone know, if you have any questions, you can type them in the chat. So because we have a Q&A session later, so we can answer all of your questions. And now, Lauren, thank you so much for being here. And then I will turn it over to you.
Okay, well then, let me just start off by saying that 2025, it's already, I'm sure some of you are already feeling the pressure of what these changes mean. And let me just be frank and say that what I think so far, what we're seeing is basically an attack on the H-1B system, unemployment immigration law in general, but the H-1B system specifically as we move into the lottery season. And, what the motivation is for that attack is hard to say. I will be the first to say that the H-1B system is not perfect. It's not what I would choose for us to have if we had, what I would consider is a better or perfect system, but it's what we've got at the moment. And it feels like, the powers that be are kind of chipping away at it. And if you get that impression, I'm going to tell you right now, you're not wrong. So this is about me. Let's move on to the next slide so that we can get started. And I know that the thing that you're all most interested in, because it's the most shocking and surprising and ridiculous part of all of this, and that is the $100,000 supplemental fee, right? It's crazy, absolutely crazy. And the fact of the matter is, not only is the idea ridiculous, but the rollout was even worse, right? Total chaos. Because no one had contemplated this. No one had notified anyone that it potentially was going to be happening. There was no proper, normally just Law 101 about regulations, and I'm sure some of you are familiar with, regulations. You're engineers, you have to be aware of regulations. But the way that things work is, Congress creates laws, and the agencies that work within those laws figure out the rules of how to implement the laws. That's where our regulations come in. So Congress said we have this H1B program, and then we're supposed to create regulations to facilitate the H1B program. But this proclamation went around that. There were no regulations. There was no Q&A portion. There was no commentary period. It was just someone woke up one day and decided that they wanted to make this $100,000 fee a part of the program. They didn't give any instructions. And again, it just created complete chaos. People were trying to fly back to the United States. They had no idea if it pertained to them. If they went to the consulate to get their visa stamp, were they going to have to shell out $100,000? Who pays the $100,000? I mean, we believe it would be the employer. I mean, it was just ridiculous. So the real question in my mind isn't who does this apply to and what is going on with it, but I'll tell you in a moment what we know so far. It's whether or not it's really going to stick. I have my serious doubts. One, it's very business unfriendly. Two, I think it might exceed authority to do something like this through a proclamation. As I said, there was no rulemaking here. This is not a regulation. It was, not done appropriately. And three, who's going to do it? I mean, I think of myself as being highly valued. I mean, I'm self-employed, but let's pretend for a moment I wasn't. And I'm on H1B or need an H1B. I mean, I think I'm pretty darn good at my job. Am I worth an additional $100,000 fee? Maybe not, probably not. And certainly if you're early in your career, and that's what a lot of H1B visas pertain to, is folks that are more recent to graduating from university than not. Maybe they're, coming from a foreign national company with limited experience, but something specialized. There's going to be a lot of companies that just are going to determine no. And on top of it, it completely closes the door on small business. Small business will not have the means to pay $100,000 fee, which goes back to the problems that we saw a few years ago. And one of the reasons why we came up with, some of the changes in recent years was to prevent companies like Microsoft, Nike, and, the various tech companies from totally and dominating the H1B system and getting, more visas than is considered their quote fair share, but attach $100,000 fee to it. And they're going to be the only companies that are going to have the ability to participate. Okay. So I talked about the actual proclamation and why and what they're thinking. I mean, again, this is an attack on the H1B program and the idea of completely rehauling employment-based immigration. I'm not necessarily against that. I'm against it the way that they are pursuing it. There has to be a better way than the H1B program, but it's not this, right? So the idea and what we understand is that this administration is hyper focused on the idea of who should qualify, who is worthy, if you will, of getting an employment-based visa to come to the United States. They want to focus on the cream of the crop, if you will, the highest paid, the most specialized, which, by the way, highest paid and highest educated and specialized don't always correlate, right? Sometimes they do, but other times no, especially if we're talking about, for instance, nonprofit type of positions, university and things, working in university labs versus private corporate labs, it will have an impact on the opportunities that are available to foreign nationals as well. Because as of right now, we all know that certain employers are more open to the idea of immigrant visas, and that may not be the same as who can pay. So those are things to consider. But yeah, they really want to make sure that they are raising those salaries or only focusing on the ones with really high salaries. Again, what does that do to the you are all engineers, so this doesn't apply to you, but for instance, what does that do for the highly experienced drug counselor at the nonprofit down the street that's barely making it to survive, but needs someone that has multiple language skills and various other things, and cultural understanding to help asylum seekers, right? And that sort of thing. That's going to potentially block them out. So this is why we're, looking at the various changes that we're seeing related to wages. The Department of Labor are, restructuring wages across the board and things of that nature. So in our estimation, the 100,000 about, creating an income or revenue stream or anything like that. It's really a way to block those. So right now, the $100,000 fee stands, but wage rules are still in progress. But the proclamation really supports that, and we'll see, what's going to happen. It's for a 12-month period. But I suspect we'll see litigation and various other things, but it might impact this year's lottery. We'll see how it goes next year. So let's move on to the next slide, and we can talk about some of the exceptions to all of this. Congratulations, none of you will be affected. Okay, that's really what this boils down to. And this we only learned after the proclamation was issued. This was, like in the FAQs the next day after everyone scrambled, got back on planes. I mean, I even heard of people that pooled their money together to pay for private private jets to get back before the proclamation went into effect, because we just didn't know. There was no real instructions, if you will. There's no guidance, but that has changed a bit, but there's still a lot of questions. So right now, as far as we know, it only will affect anyone that is outside of the United States, okay? And that it does not apply to any kind of extensions, any kind of amendments, or any kinds of transfers. Now, we all know that immigration law has a lot of nuances, a lot of exceptions. What happens if you're outside of the country for a while because you lost your employment, but your H1B is still good because you found a new job within a year? We assume that it won't apply to you. But again, the guidance is very limited at this point. We don't know what we don't know, and we're going to have to continue to monitor and see how this goes. But as far as we know, that it will have, no re-entry risks. We don't believe that it will negatively impact anyone to do things like visa stamping, spending any amount of, significant amount of time outside the United States and everything else, because it appears that this will only apply to the H1B lottery for this year and those individuals that aren't physically in the United States doing a change of status or anything like that. We also don't think that it will apply to anyone that requires consular processing, even though they've been here. That can come up when there may have been a violation of something previous, maybe something happened during your OPT. And so when you go to get your H1B, instead of doing a change of status, you have to do a consular processing. We do not believe that the $100,000 will negatively impact you, even in those situations. Okay, so the idea as of right now is that anyone that is physically here, whether you're in another status or in present H1B, you will not be impacted. Okay, now, even assuming there was going to be some type of impact, there is a national interest exception. Once again, we have not been given much guidance as to what constitutes a national interest exception. Let's go back to my example of the therapist, counselor, social worker, whatever that is helping people with social issues that require a certain level of cultural and language understanding. We assume that that person would fall within a national interest exception. We would assume that someone in medical field would fall within the national interest exception. I, for one, represent a lot of foreign national teachers that come here to teach in like language immersion schools and things of that nature. I assume that because they work for nonprofits, they'll fall within the national interest exception. But once again, until we have more formal criteria and we have been given more information about how this is going to apply, we will not know. But this is also why litigation exists, because vague rules are hard to enforce. I mean, you can't say what that we're requiring something without telling us what it is you're requiring, generally speaking, when you're dealing with legal issues. So that's where we're at in terms of the exceptions. Basically, you're here, you're good, you're there, you may not be. So, but I don't, and I see someone's message about travel does not include vacationing. I do not believe that that is true. All of that. I'll get into the question about more specifics related to salary and critical positions at the end. So, okay, let's move on to the next slide. Okay, so practical steps. I mean, One of them is budget for the $100,000 fee. I feel so ridiculous putting that in there. I mean, seriously. What a ridiculous statement. Budget for the $100,000 fee. I mean, that who's going to do that? I truly believe that employers that are affected by the $100,000 fee will simply find alternatives for this year and hope that this goes away by next year. I simply do not think that someone outside of the United States that was hoping to come here with an offer of employment during this next lottery, this next fiscal year lottery, I do not, so it'd be 2027, right? I do not believe that they will, or 26, sorry. I do not believe that they will make an offer. No, I mean, who's the only elite individuals will have this paid for. And generally speaking, if you're that elite, why would you do an H1B? Well, you know, might as well do an O1. You may want to go straight to EB1A. It just don't see it happening. So adapt to salary-based lottery. Well, okay, but we're not there yet. That's what they seem to want. Again, the idea of this and behind this and in general with the H1B is that they want to change who qualifies. They want it to be where only people that are making a certain amount of money, which in their minds, the salary equates to value, right? That if you have a high salary, it means that what you're doing is important, and therefore that's who should have an H1B. You know, forget about my foreign national teachers working in public education. Their value is less because they don't have that high salary. That's really where this all seems to be going, is that we're trying to limit who will qualify and focus on higher paid roles, which also means longer in your career, right? It does not, they're not looking at including entry level career folks. Now, there's some grumbling that there may be something else, especially if you went to university in the United States. I've always been a huge proponent of that, although I think that there's a level of privilege attached to it. Hey, your family, you were able to, come to the United States, one of the most expensive countries in the world to be educated in, and graduate, and therefore you deserve the visa. I mean, I'm an immigration lawyer. I'm a bleeding heart liberal, right? So I have some triggers on that, but the likelihood is that that is where we're going. The idea that if you studied here, you would qualify for something as well. We don't know yet for sure, but that seems to also be one of the thoughts that we educate you, we keep you, which again, there's value to that. And it makes sense that we would not want to lose. I mean, we already have a bit of a brain drain when it comes to foreign national students. So this may be the start of that. Let's revamp the H1B program with higher salary requirements, and then let's create something else. Is it an expanded OPT concept? I don't know. We already have STEM. Maybe we, extend that. Don't know. Not sure. This is all speculation. We're just trying to figure out where the administration is going with this and what we might see in proposals in the next, couple of years as they try to revamp employment-based immigration. Okay. So, we really want to make sure that as we are getting offers for positions that would require an H1B, that you're getting the appropriate salary, that they are making an appropriate offer. This is good for you. It's good for the job market in general. I mean, I'm not adverse to making sure that everyone's getting paid what they're worth. And I do think that there are plenty of employers that take advantage of the desperation of foreign national students to get an offer. I mean, I've had plenty of clients where they're like, yeah, I have someone that'll help me get an H1B. They made an offer. And I'm like, great. What's the job? Engineer? How much are they paying you? 40K a year. No. Granted, that's too lower than that's on the prevailing wage, but you get what I'm saying, is that they're trying whatever they can. So the whole advice on travel, I think that we've moved past that. This I should have updated that on my slides. This particular discussion was done really close to when the proclamation was made. So apologies on that. I don't think that visa stamping is a problem anymore. I also don't think vacationing is a problem. I think that we are just looking at those seeking an H-1B at this point, okay? And I don't think that it will have anything to do with amending or getting a new job. I think we're just at the, who is new here? Who hasn't had an H-1B before and is getting it now? The administration is basically, okay, you all have your H-1B. We're going to leave you alone, but we're going to scrutinize everyone else as they're coming to us. And the whole aspect of, if you're already here as a student or something, it's kind of the idea of, well, you came with the idea that you had this H-1B option at the end of the role, that you already had committed to studying here, graduating with the hopes of getting that H-1B. We won't penalize you for that either. We'll let you do a change of status in the United States. Again, some of these questions have not been answered yet. We're making a lot of assumptions still. The only real guidance that we've received is an FAQ from DHS and a one White House briefing. The rest of it is those of us in the industry having ad nauseum discussions with nobody officially providing us guidance. Okay. And some of the guidance that we've gotten has been completely irrational. It's got to be wrong because it doesn't fit within law or regulations as of yet. So this is still, we're not there yet. Some of these answers that I know some of you are looking for, I cannot give them to you definitively. Just cannot. So yeah. Can anything be done about this? The folks in downtown get paid more. Yeah, no, at this point, no. The only thing that you can really do about anything that is related to salary, and that we're still in this rulemaking and DOL, is go to the Federal Register and make your thoughts known. That's it. When we get a regulation, when there's a change on salary or how an agency is going to implement a law or do their jobs, okay? Once again, I know that a lot of you work with regulations every day, but the way that regulations are promulgated is simply Congress makes laws, which govern the, what we're supposed to do. The agencies make regulations so that they know how to implement the laws. Okay. And in order for them to change their regulations or to implement new regulations or anything else, they have to go through the Federal Register and have a rulemaking period and comments and everything else before they get to the final rule. So, assuming that the comments, and I don't recall, are still open and available in terms of any of these salary changes, there's really nothing you can do. If at some point it determines that the salary changes are totally and truly unfair, unjust, doesn't comply with statutory interpretation and things like that, that's when lawyers go in and sue. So, I mean, that would be an option. But I don't know how many of you have gone into the DOL website to determine salaries and everything. When it comes to the Chicagoland area, it's the Chicago metro area that includes like out to Naperville, all of Chicago, probably up to I think it even includes Kenosha. I mean, as opposed to Kenosha belonging to Milwaukee. Okay. And everyone within that area has to meet the same salary requirements. So yeah, someone that is working in downtown Chicago, the salary is the same as someone that is working in Gurnee, Illinois, or supposedly supposed to be the same. That's just how these salary bands work. And the only other option is to do a private salary. And this is more along the lines for perm than H1B, but you can do a private salary survey. So, okay, let's move on to the next slide. I think we've even covered some of the things. No, and I discussed this for any of you that attended the last H1B discussion that we had. I actually addressed this then, but I felt like it was still relevant today because there is, first of all, if you are here without an H1B right now and you're still a student, you're still on OPT or whatever, and you are trying to determine what's going to happen moving forward, and if we get more directions and more appropriate guidance on this fee, we just don't know. And then of course the salaries start to complicate things too. An employer may not be ready to offer an H1B position to you in your first year of STEM, right? They may be thinking, okay, I just can't do it. Not when these salary bands have gone up to a higher level. I'm going to have to keep you just on OPT for now, and we'll talk about it next year, because I'm always an advocate that, hey, try to get into that lottery as soon as possible, right? Because you want to have 2-3 opportunities to get chosen, but that may not be practical anymore. So what are our options instead? We have day one CPT. Be careful about this, especially with the present administration. I'm sure that they have their sights set on these schools that offer day one CPT. So make sure that you're really looking at the credibility of the school, their certifications, their licensing, and everything else before you go to that program and participate. Make sure that you're actually doing the program, that it's not just a way to get CPT. Okay, we need it to be a part of your career trajectory and has true connection to what you're going to be doing. Okay. No one likes it, but I keep trying to promote it. And that is leave the United States for a while. People, especially now, we have all recognized, I would think at this point, that the United States is not the end all be all of places to live and work and promote your career and everything else. It's expensive to live here. It's stressful to live here. We are on low markers in lots of different ways. And I know this is ironic coming from the person that brings people to the United States. I'm a firm believer in what we have here, but simultaneously, it's not the only place that it exists. So if you work for a company that has a national entity, propose working there for a couple of years and come back on the L1. Okay. And better yet, if it's an L1A management, executive, you now are EB1. It is a great opportunity for your career as well. So people always get nervous and twitchy when I start talking about this, but I think it's something that you really should consider. Pursuing a higher degree, which same as day one CPT, right? More or less. But this is probably, I'm looking at those of you who have gotten your bachelor's degree and are moving on to a master's degree in the same subject matter, as opposed to, a like an MBA with day one CPT. This would be more of, okay, I've started my master's in engineering, or chemistry, or whatever the case, data science, whatever the case might be. And as I'm going through my new master's degree, I would also like to work. And that's when, you go to your school's foreign national student advisor and you seek employment with them. That may not end up being the job that you had. And that's something that you have to be open to. But if you feel a need to work, whether that is to support yourself because you weren't planning on a master's degree, you don't have the same, family support system that you previously had, things of that nature, this is an option. I would also say for any of you that are in, your bachelor's degree period right now, and you have paid for it yourself through family, or whatever the case might be, student loans back home, I don't know. Master's programs are different in terms of funding. So don't wait if you think that a master's program or a PhD program is something in your future. Start looking for those funding options and opportunities while you are in the midst of your bachelor's program. Funding is more available for foreign national students in master's programs than what it is for undergrads. So, do your homework, think about that. 01, extraordinary ability. You're not going to get it usually if you're early in your career, unless there is something really, really special about you. And the same is true for an EB1A or a national interest waiver. And if we go to the next slide, Molly, if you could push it to the next one. I think I have all the list of the different options. Yes. So here's the thing. I go on Reddit and various other places and lurk in these groups where y'all are talking about your bios and various other things. And I rarely say anything, but none of it matters. Okay. Counting your publications and how many times you have been published, unless you are truly prolific, does not matter. You could be published 1,000 times though, but if nobody else is using your work and thinking about it, and putting it into their research or their work, it does not matter. Creating PR about yourself and doing pay for play interviews and trying to get, attention does not matter. None of that is credible evidence. I've said it before. I will say it again until I'm blue in the face. Lean into your career. Do the work. Okay, that is how you're going to get any one of these things. Even the H1B. How are you going to get an H1B offer when you are in STEM? Do a great job. Do the work. Make yourself important to the employer. How are you going to get an L1 visa transferee? Get the job abroad, make yourself so important, so relevant that they want to bring you back to the United States. How do you get an O1? Do something. Do something that is, take the opportunities. Volunteer for the committees. Volunteer to judge people's work. Go out there and find the opportunities. Get involved in the research. Do the work. EB2, EB3, we all know perms. I tell my employer clients to usually wait about a year before investing in the perm, because I think it's only fair that they know that they want you and that you want them. You don't want to get into this relationship so quickly, so soon into it, that either one of you end up in in a bad marriage, if you will, where you can't really divorce because the employer invested in you and feels bad that this may not be good. No, EB3, who knows if it's going to go away? I mean, these people have not, again, they want to only do things for the most educated, the most important. Whether or not that actually happens, it's hard to say. As of right now, it would take an act of Congress, and Congress has not done anything real when it comes to immigration for the totality of my career, which started in 2002. So most likely you're all safe. Not that you'd be EB3 anyway. As I was going back to what I was saying, don't get into a bad marriage with an employer just because you are so focused on getting a perm started. I understand why it's important sometimes. I understand, 6 years and extensions on H1B, especially if you're from India or China. I understand having a spouse that is going crazy because they're not able to work because the I-140 hasn't been approved. I get all of that, but be careful, just be careful. And you want an employer that you can trust, that you feel committed to, that you're willing to work for a significant amount of time, even though, again, you're not an indentured servant. Their porting exists and various other things, but it gets messy. So be careful. EB1, we're seeing a lot of pushback. Seriously, RFEs are out of control. They're out of control everywhere, but we just want to make sure that we're, being circumspect when we decide whether or not to pursue an EB1. They're not meant for everyone. They really aren't. And the fact of the matter is a lot of people that that come to the United States to study and to pursue employment, you're the best of the best, right? It's kind of like this thing right now going on where they're saying that Harvard hands out too many A's, and the students are up in arms about it because they're used to getting A's. They're in Harvard, for goodness sakes. The idea of not getting an A blows their mind, but not, not everyone is going to do A work. And if you're graded on a curve, which immigration is definitely a curve, not everyone is going to get the EB1. Okay. So don't waste your money or your time or your efforts on pursuing it unless you have done the work. And when I say doing the work, I don't mean your bio. I mean the actual work. Go out there and do things at your job. So perm, which I already discussed, and who cares about H2A and H2Bs in this discussion? We don't. What I didn't put down here is the NIW, I guess, as a separate option. And I imagine many of you are interested in the NIW, as you should be, okay? As you should be. And it is a good alternative to long-term, having to stay with an H1B long-term, especially if you can do an O1 and NIW together. But the point is that you still have to qualify. You still have to do the work. And again, that's not immigration work, that is career work. And I would recommend that you come down with a plan for your career, not for your immigration journey. People want to put the cart before the horse, right? They want to talk about immigration. I want to talk about your career. I want to talk about what are your plans for, becoming the secretary or treasurer of your national organization, right? When are you going to be the one tapped by a local news agency when a bridge collapses? That's what you need to be working on, right? Not worrying about whether or not if this qualifies for an NIW. Don't even worry about it yet. Worry about whether or not it's good for your career, because everything will happen the way it's supposed to happen if you do it that way. So let's move on to the next slide. Although I think we are very close to, yeah. Okay, so these are just some thoughts. And again, it's all speculation. Nobody really knows. We haven't received guidance, but lawsuits are already underway. We don't know what will stick, what won't stick. We don't know if the whole thing will be tossed out, if it'll be delayed, if it will have to go through actual rulemaking. It's just completely uncertain at this point, and we'll just have to wait for it. Okay. The nice thing about proclamations and presidential, executive orders and stuff like that is that they're not permanent. They change. It's also the bad thing. I mean, that when we circumvent Congress and rulemaking with regulations, we leave everything up to complete chaos and the whims of an administration. And here we are, we're on a whim, and whether it sticks or not is, anybody's guess. But we also don't know what the next administration is going to hold. Is the next immigration going to be pro-immigration or anti-immigration? It's hard to say. Economies and economic factors are a huge driver of immigration changes and shifts, as are, economic factors as it relates to social programs and taxes and all that. I mean, you're a very small portion of a much larger discussion, and that's something to be aware of. So how this will affect the labor market is anyone's guess as well. And the reason why the salary issue is up is that some people firmly believe that foreign national labor, even in the professional sectors, brings salaries down across the board. The fact of the matter is the United States has had stagnant salaries for a very long time, especially in industries unrelated to yours. Engineering has done better than others. But if you go to, certain industries, let's say your local librarian that has to have a master's and know all kinds of things about really complicated research and writing and citations and things like that. Public libraries are offering her $18 an hour. That's ridiculous, right? A licensed social worker is lucky to make $15 an hour with a master's degree. So the salaries are stagnant. We're not, no one's going to argue that. Whether or not it has anything to do with immigration is a completely different question, and one that I think is kind of, unrelated to the H1B issue or even the labor certification issue. But sometimes people don't see nuance, and this is all above my pay grade. So we'll see how it goes. And then as far as I said, is there anything to do to stop the salary changes and the bans on that? Or is there any way to stop a $100,000 fee on an H1B? I mean, sure. And if you want to be a part of that, and I caution you when it comes to doing anything these days that is not aligned with what this administration wants, but I would say trade groups and things like that are a very important part of that, and that you should be looking at those things, not just because it may help your immigration case, but more because what am I saying? Do the work and join the group, join the organization, be a part of your industry. And this is a way to, kill two birds with one stone sort of thing. You're not only doing it for yourself in terms of your employment trajectory, your networking, your opportunity seeking, your ability to get your name recognized out there, but you're also doing something that can help on the immigration side as well, because these organizations are the ones that are being asked their opinion about rulemaking, and they're being the ones tapped by lawmakers in order for those lawmakers to have an opinion on a proposal or a rule change or anything like that. I mean, Tammy Duckworth is listening to trade organizations and other organizations when she is making her decisions about how to approach immigration policy making. So why not be the person in the room? You have just as much opportunities to be a part of that as anyone else if you decide to do it. So that's where I think you can make a real decision. And then, of course, look to find out what organizations are fighting some of these things and contribute to that as well. There are groups out there that are a part of the litigation process that are trying to stop this on your behalf. And they can't do that in a vacuum. They have to have funding and various other things. So, that's another option that you have. But again, as foreign nationals, you need to be careful with everything that you're doing. What are some other options that you could look to kind of help facilitate different, things? I still think that remote work and global mobility is something that you shouldn't necessarily turn a blind eye to, because those opportunities are resume packers. And when you go to a smaller market, sometimes you get more opportunities that can lead to things like national interest waivers and EB1 worthy resume, qualifications. So, but I think we have one or two more slides. I do not recall exactly, because I have a Q&A. So Molly, if we could. Yeah. So here, and we'll go through your questions as well. Will the 100K fee apply to transfers or extensions? We do not think so. Okay. As of right now, that's what they're telling us. No. Can we avoid the fee if the employee is already in the United States? That's the gist of it. That it appears that even if you're not in H1B status, as long as you are in a status in the United States, you're okay. Travel should be fine. As far as we know, there is nothing triggering, in that the $100,000 fee will only be triggered at the lottery come March. Okay. Case study. I just put in some samples here. Plans to onboard foreign developers in Q4 2025, shifted to remote work, and initiated EB2 NIW filings to avoid fee and reentry delays. These are the kinds of strategies that your immigration attorney should be discussing with HR, with individuals, with companies, to figure out, well, okay, assuming that the $100,000 sticks, we're not doing it. What are our other options? The L visa, for instance, the EB2, NIW, whatever the case may be, there's in O1s. There are other options to consider, so that you're not paying a ridiculous, shakedown fee to the United States government. Small healthcare provider, I do believe that they will be considered exempt. They're already cap exempt. I think that I'm hoping most cap exempt employers will also qualify for the exception on the $100,000 fee. We'll see. Let's go to the next slide. Key takeaways, same thing I've been saying. Applies only to new petitions for beneficiaries outside the US, but not just, not like even new cap exempt. It appears that it's just the lottery come this spring. Travel visa timing and petition type will determine whether restrictions apply. As of right now, again, I should have updated this. We do not believe that travel will be at issue. Then employers should prepare for a wage-based lottery. Yes, I doubt that it's going to happen this year, okay, for this next lottery. But we will have those new bands. So higher salaries are coming in that regard, whether we want it or not. Viable options, alternatives. I mean, those are the same things we go through every year when someone doesn't get chosen for the H1B lottery anyway. It's the same thing. What can we, how can we put together a plan that gets you to the same place as you wanted to be, whether you got the H1B or not. And then finally, litigation and what, you know, a new administration will do. We don't know what the future holds. We don't know how this is going to continue and whether or not it's even going to be here. Okay, I think that's it. I think that's all I have in terms of uh, slides. So, but we do have some questions. So, and we probably have some people that didn't even put questions in, but have some that they
Yeah,
want to have addressed. Yeah.
yeah. So then there are a couple questions in chat. Lauren, can you take a look at their questions?
I'm going through, let's see, I'll go all the way up to the top. Yes, it is recorded. And that's not where, let's see, what do we got here? Why is it not moving for me? Okay, so if you have any questions, okay, when this says only concern is if they travel, does that include vacationing? No, I don't think it's gonna, again, we don't believe that travel is an issue regardless, as long as you have your H1B. And even if you don't, if you have status in the United States, right? And that the idea will be that when a company enters the H1B lottery for the first time for someone outside the United States, that's when this fee would kick in. So think of it kind of like, well, if you're already here, we've got you, we're okay with it, you're part of the status quo, but we don't want anyone new, you know, and or we want, if you're going to bring in someone new, we want to make sure that that someone really, really, really is necessary and qualifies for this benefit. Okay, so next one. Will this be applicable in text industry or targeted to every industry? I assume this is, are we talking about the salaries then of the shortage? Yeah, they don't care about shortages, just so you know. I know that sounds, again, the Immigration Service has no concept of actual business needs and that sort of thing. And we have not had any actual immigration reform in over 25 years. Okay, we've got these little band-aids here and there and various regulations and little you know, little tweaks. The reason lotteries and create a lottery system is that was a regulation. The law already said there's going to be H1B visas, and here are the people that qualify for an H1B visa. But it didn't tell the Immigration Service or the Department of Labor how to facilitate and execute the H1B program. So they could, the Immigration Service could say, you know what, the way that we're going to issue H1Bs isn't, you know, you mail it in and we'll pick, you know, randomly who we're going to choose to give an H1B to after you've mailed in your whole packet. Instead, we're going to do a lottery system where you register and we'll pick you ahead of time and then you mail. They could do that because the lottery had already been set up by Congress. That was already decided. How you do the lottery was the regulation, and the Immigration Service could change that. So as of right now, anything that any of you have ever seen related to immigration has either been an overstep of an administration by doing some kind of proclamation or something else. I mean, DACA is a perfect example. If you know anyone on DACA, the reason why it's been litigated for the past 13 years is because Obama didn't follow the rules to create it. Okay. It didn't go through the Federal Register and regulation making and rule making and all of that. So anything that any of you have seen, it's not a law change. It's a regulation change. And so unless Congress decides that we need more engineers, for example, it doesn't matter that we are in desperate need of engineers. They have to change the law. Okay, we do have some specific laws regarding nurses, but even those have been rolled back at different times because the regulations allowed for it. Okay, and second question, wage-based selection. Medium and for freshers like me under 100K, less than tech-based companies. Will DOL determine wage levels based on industry, or will wage levels? It's all data driven. It's all data driven. It's the way that they determine prevailing wages is surveys, and it's a combination of industry, skill set, and everything else. And I will not pretend that I know how to do it, because if there's one thing I am not, it's anything to do with numbers. There's a reason I went to law school. Okay. So, but it will determine wage levels based on industry, or will remain the same for all industries as median salary. No, your salaries are specific to what you do, what degrees you have, where you are, what skills are required, the number of years of experience, which, is why a teacher is going to have a different salary base than an engineer. And I assume that please clarify where I, didn't understand and answered incorrectly. Okay, a case of a person with a valid H1B and was laid off while visiting overseas. I think so. I don't think that they will be subject to the $100,000 fee. I think based upon what we know at the moment, because they would not be, they're not cap, they would be cap exempt at that point. We believe that the $100,000 fee would not attach to them. Okay, so that's how it is being determined as of right now. To make sure I understand, if a person already has their H1 visa that is not up for renewal currently, yes, you can travel, come back. It shouldn't be an issue. As of right now, anyone in H1B, proper H1B, with or without even a visa stamp, let's say you're going to Canada or Mexico or one of the particular islands that you're allowed to go to without getting a new stamp and doing auto revalidation, you should be able to travel. You should be fine. Okay. Anand, DOL established, I think I addressed this to a certain extent. What can be done about it is a private survey. But the problem with, I will say, the problem with private surveys is they themselves are expensive. I forget, there's a few companies out there like PricewaterhouseCoopers, I think, does a private salary survey, and some other, larger companies do them. And even though they have all the data ready to go and probably can give you the answer just like that, when you go to request the survey, they act like it's, like they're redoing and going out and requesting information and analyzing the data right then and there to give you what you want. So they're expensive. So you have to, weigh the pros and cons of whether or not it's relevant. But if you're talking, a 20,000 plus difference in salary, then it's, it could be potentially a good idea to do a private survey. But simultaneously, what if it doesn't result in what you want? What if the private survey is close to what the Department of Labor? Department of Labor is always higher, but yeah. EB3 going away. Again, we don't know, speculation. The point is that this particular administration thinks of immigration in terms of class and education and salary. Okay, it's a privilege, and which means that, I mean, I do perms for housekeepers and nannies, because we need people to do that work too, and you don't always have everyone available, and those are EB3s and other workers and things like that. But as of right now, we don't know what the future holds. I think EB3 is safe. I think other workers is the one that really could be on the chopping block. So okay, is there a limit on how many times a person can go from H1 to H4? Then no. I mean, it can get a little messy. Have a good attorney helping you with it, but no, you can. I see this all the time. You can go back and forth as needed. Be sure to check your, keep a good track on your days and, recapturing time and stuff of that nature. But no, you can do what needs to be done. Considering the prolonged H1B extension process time, is there any restrictions on starting the perm process filing? No, one has nothing to do with the other. I could, if you had an employer, let's say that you met someone your freshman year of college, and that person said, oh, I really want, let's not say college. Let's say your first year in master's program, because I want you to have a bachelor's as I'm going through this scenario. And you met a company, met a small business, and they're like, we really want him forever. We know he's right for our company. This is something that we want. How do we make that happen? Even before you graduate, even before you start working for them on STEM, maybe you're just doing some CPT, maybe you did an internship with them. I don't care. It doesn't matter. If they say we want them, I can start your perm right then. As long as you meet the objective criteria that the company says that they want for the job, your H1B is completely, or whatever other status you're in, is completely irrelevant to petitioning you for a green card or a visa to apply for a green card through the labor certification process. None of them, they're just completely irrelevant to one another. Okay. If one wants to move to a new job on H1B with I-140 approval to a new location where the wage levels are lower per OFLC data center, then will that be a concern? No, there are ways to deal with that. But again, use an attorney. Okay. Why was it advised to get on H1B as soon as possible, even if you are on OPT? Because you get 3 shots at the apple there, there's only so many lotteries, and I've had people go through it each year on STEM OPT and they never get chosen. Yet you might as well get in there as soon as you can and get as many opportunities as possible to win a spot. Okay, this year I think we'll have fewer applicants, so more people will qualify percentage wise. But yeah, does the $100,000 fee apply to an individual who is changing? Not if you're on H4, because you're here. Once again, as far as we can tell, this will only pertain to people outside the United States. As long as you're here, it should be good. So yeah, considering if the wage-based selections is implemented, what are the odds for, I do not know what the odds will be to get selected for the H1B in the lottery. I don't know if you'll qualify. That's the thing. We don't know what this future idea holds as far as creating, a merit based, because I think that's what they're trying to say it is more merit based, but with a salary component. Okay, that they want to include how much money you're making as a part of the criteria of worthiness. Right now, we're looking at, your degree, your experience. And when it comes to certain elements, and depending upon the visa type, we're looking at, what certifications do you hold? What licenses do you have? All those types of things. But salary was never a part of it, like what someone offered to pay you. Pay was subject to the requirements, the bands, right? And the prevailing wage requirements. Whereas now they're saying, we're not going to tell you necessarily. I mean, they still would, but we want you to tell us or show us how important this person is, because you're paying them an important set level of salary. Okay. So if you're paying this person $250,000 a year, we think that they're worthy, right? That means that they are worthy of getting a visa, because at $250,000 a year, obviously they're of high value. And those are the types of immigrants that we want. High value immigrants. Okay. So, and yeah, and that's really what that is about in terms of salary. It's also what the fee is about. It's about putting value. Okay. So if that is it, I think, yeah, I think I've answered all the questions. So, if you have any questions, this is my information. I'm happy to provide you. If you would like to, you can register for our newsletter on our website, or take a look at that. We try to update people as they come along. These things, I always recommend that you find credible sources for this information. I mean, I'll continue to lurk on your Reddit groups and Slack and all that, but I'll be perfectly honest, at least half the information is wrong. So keep that in mind, and don't watch anything on TikTok. So unless it's me, no, I'm just joking. There are plenty of appropriate things out there, but just, keep note that not everything is accurate, and it shouldn't raise your blood pressure every time you see a potential change. The credibility on this kind of information is really important right now, and we want to make sure that you're getting the right information to make really important decisions. But a lot of what we discussed today is high level stuff, and it is important to make sure that you are getting good advice and putting in the effort and things of that nature to make sure that you approach it appropriately. Okay, and that's true for employers and employees. Okay, when we will detail update from the DOL from these new reforms, I'm not exactly sure, to be perfectly honest, and I do apologize. I do not know, but if you register for some various attorneys' websites and updates, you'll get that information. AILA is always a good source for that as well. Okay.
Yeah, I think that's all the questions we have. And thank you so much, Lauren, for sharing your expertise and your time. And thank you, everyone, for joining us today's webinar. And I know it's a little bit late, so we hope this session was helpful. Thank you, Lauren.
Thank you. Have a good day, everybody. Bye-bye.
Bye, everyone.